I think that does lead in well to our next topic. We've kind of just been talking about this in comparing the eligibility and timing between IPR and re-exams. Obviously, IPRs have a lot more limitations placed on them, as we've been talking about. There might be instances where you don't even have the option to file an IPR, whether that's because of a declaratory judgment or the one-year time bar. And to Eliar's point about timing, I think it's when you're a defendant faced with district court litigation, I think it's also valuable how quickly you might get statements on the record by the patent owner about their patent. And so for an IPR, for example, if the patent owner chooses not even to file a POPR, it could be 8 or 9 months before you receive any substantive paper from the patent owner talking about or making arguments on their patent. And so with the re-exam, because for all the reasons we've talking about, that it's much quicker to get an S&Q, that also, as a defendant, would allow you to get statements on the record that could then in turn be used in the litigation. Statements from the patent owner about their patent come at a much earlier time in the re-exam process.
And potentially statements from the patent office itself too.
Right.
You know, getting just another data point.
Yeah, and the sad thing for the patent owner is that, you know, their statements follow through to the litigation, whereas the third-party requester or the petitioner can argue that it's a different standard, or even though it's the Phillips standard, it doesn't have the same evidentiary requirements. So the third-party requester can have a little leeway, whereas the patent owner, they're his statements. They're their statements, and that's it. They don't have much leeway at all.
And that kind of carries through throughout the course of the parallel litigation, right? So there's no one-year time bar with re-examination. So that problem is a constant problem, you know. So to the extent a late re-exam gets requested, even if the case isn't stayed, but there's always this sort of looming issue of, you know, what gets said and how does that impact what's going on in the district court litigation, whether it's related to claim construction or, you know, reasons to reopen discovery or serve new invalidity or, you know, infringement contentions. So it seems to be an ongoing issue.